Hi, it's Chris Jackman from the Aberdeen Law Firm, and today's episode, I'd like to talk to you about things that you should not do in your family law case. Having done this for almost a decade now, or actually a little over, I've seen a lot of mistakes that people have made over the years, and I've noticed some common ones that I see over and over again. And I think if you could just hear this out and follow these instructions, it'll help your case a lot, and it'll also help save you a lot of money on legal fees, as well as probably get your case going a lot faster. Because when I've talked to all of my clients over the years, the number one complaint, aside from the overall cost of their case, is just how long their case can often take. And that's why today I want to touch on a handful of things that I just see people make over and over again, in hopes that if you hear these and you stay clear of doing these things, you will speed up your case and it'll save you money. So, number one mistake I see people make, and I know this is going to sound very simple, but it's just not listening to their lawyer. Over and over again, I meet with lawyers at my firm and I meet with clients, and a lot of times the biggest issue that we're seeing is that people just don't follow their lawyer's instructions. And I think on a big picture level, we just have to remember that, family law lawyers do this day in and day out, week in and week out. We see and have seen pretty much everything under the sun. So nothing is really going to come as a surprise to us. And, big picture, we know how to strategically handle your case. And when we have our clients kind of pushing back and wanting to do things their own way, it really creates friction and it can really slow the process down. So I would encourage you really fundamentally follow what your lawyer is telling you to do to the T, and chances are it will be the right thing to do for your case. The second biggest mistake I see people make is how long it can take our clients, to get our lawyers or our paralegals the information that we need to move forward with your case. And this is particularly true at the very beginning of the case, because at the very beginning of the case, regardless if you're the one who's filing for a divorce or any kind of family law case, or if you're the one responding to your ex's documents, there's a lot of documents and a lot of information gathering that goes on in the beginning stages of the case. And the longer that you, the client, take to get that document to us or documents to us, the longer it just slows it down. And I've had some cases over the years where my client's case was really set back, from a negative standpoint, because it took so long for my client to get back to me with the information that we needed. And my client was disadvantaged because a case ended up being filed in a county that we didn't want to be in. And there is a certain advantage to being the first to file the documents, because if you're the first to file the documents in court, you get to say whether the case goes forward or not. And I've had cases over the years where my client's ex decided they didn't want to go forward with the case any longer. My client did, but the ex didn't, and the case was dismissed. And then my client had to file his own case, and the whole process was started all over again. And this was all because my client, even though he wanted to be the first to file the case, just wasn't able to do it because he wasn't able to get back to me with the documents that we needed. So again, the number two most common mistake I see is just not getting us or your paralegal the information that we need. We use a software system that makes it pretty easy for our clients to upload information, but I can tell you that if you're thinking about getting a divorce, separating from your ex, getting some basic information like birth certificates, if you have multiple children, getting, tax returns, bank statements, credit card statements, things that we're definitely going to need. And those are the common documents that we need, by the way, our bank statements, wage statements, credit card statements, tax returns, things that are going to validate or support how much money you're making. We really need those. So before you reach out to a lawyer, you might want to take the time to go through and get those documents, because we're going to need them. That's the number two most common mistake that I see. The number three most common mistake that I see is, and I know this might sound odd, but it's that clients who just aren't being totally honest with us, the lawyer, which I find odd because the truth is that anything that you communicate to your lawyer is confidential. So there's no reason not to be completely honest with your lawyer about what's going on in your life. I just over the years have had so many clients play hide the ball, or they don't want to be really forthcoming with things like how much money they're making, how much money they have in various accounts. And, we just, as lawyers, we never want to see our clients get in binds and get in positions where they look like they're not being truthful, or they look like they're the ones that are kind of, hate to say it, look like they're lying. Because in most cases, if you're going up against a pretty competent and assertive attorney, that attorney is going to eventually uncover the truth. Now, obviously, if you are hiding money, in offshore accounts, or you're putting it under your mattress, no one's probably going to find out about that. But in today's world, if you have money in a bank account or some sort of brokerage account like a Charles Schwab or a Edward Jones account, a TD Ameritrade account, things like that, those are all things that can, within reason, be discovered. And we just never want to be in a situation where the opposing attorney files or sends what's called a subpoena, because that's a legal document that allows the attorney to get financial documents. And, if you are in a position where you've said one thing to your lawyer and that's been communicated to opposing counsel, or worse, if you say things under oath, either in written discovery that you have to do during the course of your case, or if you have to take a deposition and you say something and then a month or 6 months pass by, and the attorney through that subpoena is allowed to get documents that show that what you said was incorrect, there's the possibility that you could be opening yourself up to what's called perjury. And perjury just means lying under oath, and it's actually a federal crime. I've had clients over the years that actually want to go after their spouse for perjury, because through what I was able to do, sending legal documents such as subpoenas, I was able to show that a spouse had perjured himself or herself. And it's a very serious thing, and it's just not something you want to get yourself into. So that's number three. And just to do a quick recap, the three biggest things I see are clients who, are not cooperating with a lawyer, number one. Number two, who are not, really diligently getting back to us with the information that we need. And number three, they're just not being entirely truthful, with their lawyer. I would say a number four problem that I commonly see is the inability for people to get witnesses on their side. And that's something that's kind of within the client's control to an extent, right? Because if you don't have witnesses, especially if you're in, and I'm just mentioning this because this is the most common case type that we see, is parents fighting over custody of a child or visitation of a child. And in those kinds of cases, unless you just have really hard and fast evidence in the form of Child Protective Services or a police report that really comes down on one parent over the other, absent that, the only thing that you really have going for you in a lot of cases is witnesses, or our witnesses, family, friends, coworkers, people who can really speak to you as a parent and what kind of parent you are. And so I think a lot of times what people do is that, and oftentimes it's because they're embarrassed, or because they don't want to burden a family, friend, coworker, neighbor, but the truth is that if you come across fairly credible, and your spouse or ex come across as fairly credible, and you both want very different things for your child in terms of visitation, it's going to be really hard for a judge to make a decision. But if you have credible, independent witnesses who are going to come on your behalf and are willing to come to court and testify and explain to the judge why you're the better parent or what you offer as a parent, if you don't have that, it just makes our job as your lawyer incredibly difficult. So, whether you're contemplating or you're actually in the thick of a divorce and you're going through the process, think about these people in your life that might be able to help you, because those folks can make an enormous difference in terms of supporting your credibility. So that is the fourth thing that I see. The fifth thing I see, and I think this is a small thing, but it's not really documenting and record keeping your case effectively. A really simple thing to do in terms of showing or being able to show the kind of parent you are is to post things on social media about yourself when you have your child. If you're an active social media user, it's very easy for you to really document the things that you're doing with your child when you have him or her in your custody or your possession at a given time, right? So if you go to a park, you could easily just post a picture of you with your child on Facebook and Instagram, and then we can use that as what's called an exhibit to show the judge. Right? So that's an easy example of things that you can proactively do to kind of create a written record of the kind of parent that you are. Now, obviously, if you have harmful things that are on social media that don't look, really good on you, those are things you probably want to remove. But thinking about kind of having our record that we can use from a document standpoint to show the judge in the event that we go to court, either for a mini hearing or for actual full-blown trial, that's really going to help your case. And it's not just from a custody standpoint, showing pictures of you with your child. It can also be from a document standpoint in terms of proving how much money you make or don't make. Just because an often common complaint that we get is that spouses are not being honest with how much money they're making, and there's a huge dispute or argument over how much the child support should be, or how much the spousal support should be if spousal support's requested. But without documents to really back that up, and again, we're just talking about tax returns. We're talking about wage statements from your company, wherever you work, brokerage accounts, if you have one, retirement accounts. If we don't have those things, it's really hard for us to make an argument one way or the other. So my advice to you is don't be like a lot of clients and have poor record keeping. Take it upon yourself to get those documents. I know they're scattered sometimes, but find those documents, get them organized for us so we can use those to help with your case. So those are the 5 biggest mistakes that I see people make with their cases. If you are considering going through a divorce or trying to get custody of your child or anything that's related to family law, and if you have a question about what I've just gone over today, or you have a concern that you want to bring up with your case, feel free to give us a call. We'd love to speak to you and sit down with you and see if we can come up with a strategy to have you avoid those 5 things. Until next time, I look forward to speaking to you, and have a good day.